Hi, my name is David Slottje. The screen says that my lovely bride is supposed to be here tonight. She can't be here. She's a little run down. This is actually the 7th one of these this week that we have done. I will explain toward the end of my presentation why, but quite a few communities in upstate have made the decision that they want to do something, and these are communities that may be divided about gas drilling, or the town board or the city council may be divided about gas drilling, but they have decided, for reasons that I'll get into at the end of my presentation, that it, at least for them, might make sense to do something now before permits issue. So that's why she's not here, and she apologizes. Is this okay? I'm sorry, Chris, but I can't really stand still. So what I'm going to talk about tonight is a little more focused than what Guy was talking about. Guy touched on quite a few things, valuable tools for municipality. I'm going to focus on one particular use, industrial scale gas drilling. And I'm going to talk about what a municipality can do using police power-based land use laws, not zoning. What I'm talking about here doesn't have anything to do with zoning. Zoning is a police power-based law. All zoning laws are police power laws, but not all police power laws are zoning laws. So I'm going to talk about using police power-based laws, land use laws, to the extent that a community wants to use those to restrict industrial scale gas drilling. I'm not going to get into whether or not a community should want to do that. I have an opinion on it, to be sure, but I'm just going to try to do my best not to be an advocate and just tell you from a lawyer's perspective what a community can do. Before we start, some people have asked whether the town, or any town for that matter, has the right to ban industrial uses, any industrial uses, not just, say, gas drilling. I'm going to sit here because I'm getting feedback here. These people have heard, especially the people up at the front of the room, and I guess some of the people in the audience are in their own towns, people in the front of the room. People in the front of the room have heard for years from folks like the Association of Towns that towns do not have the legal authority to outright ban certain uses, certain so-called adult uses, for example, or housing for people of very limited means. And so they wonder whether those restrictions might also apply to banning heavy industrial uses. They do not. This is really, really important. They do not. You should not extrapolate from the fact that you cannot ban adult uses. You should not assume because of that you cannot ban heavy industrial uses. The legal rules restricting municipalities from outlawing those uses I just mentioned are very limited, very specific in nature. They have to do with protection of constitutional rights, specifically so-called First Amendment rights such as freedom of speech and freedom of association. But there is no question that exclusion of heavy industrial uses is a proper and legitimate use of land use laws. No question. It's what lawyers call black letter law. You won't find a single lawyer tell you otherwise. Okay. Guy touched on this with a lot more detail, but I want to focus on municipal home rule law. This gives towns police power to enact laws relating to the protection and enhancement of your physical and visual environment, and for the protection, order, conduct, safety, health, and well-being of your townspeople and the property within the town. This is what we're going to use if you want to do this, the police power. So there's no question, in a vacuum, you've got the right to pass these kind of laws, but we're not operating in a vacuum. There is a law, I'm going to refer to it as the gas mining statute. It's ECL 230303 subsection 2. You're going to hear a lot about this. And what that says is that a locality is prohibited from passing local laws, quote, relating to the regulation, close quote, relating to the regulation of the oil, gas, and solution mining industries, Oil and gas industries are what they sound like. Solution mining is salt mining. And then it goes on to say that, by the way, this provision I just read to you does not supersede your right to have jurisdiction over local rules. So this is a really important statute because people will come in and they'll pound the table and they will tell you, you cannot regulate the gas industry. And they're right, and we agree. But from our perspective, that doesn't have anything to do with the price of tea in China. So what does supersede all local laws relating to the regulation of gas mining mean? Guy mentioned to you before that in New York State, the highest court is the Court of Appeals. Whenever you're talking to a lawyer, particularly in New York State, you want to really focus on what they're saying. If they tell you Supreme Court, most of us are used to hearing Supreme Court. We think United States Supreme Court, that's the highest court there is. In New York State, the Supreme Court is the lowest court. It's a trial court. So the highest court is the Court of Appeals. So when you're participating in something like this, you want to have your ears prick up a little bit when the lawyer says New York State Court of Appeals, because that's the highest court there is in the state. All right? The highest court in New York State, the Court of Appeals, Sure.
We're talking section law, we're talking case study, not statute and jurisdiction. The Court of Appeals is separate, but not higher or lower. Am I correct?
No, you're not. The issue, most of you know what the United States Supreme Court, that is the court of last resort. That is the court where if that court decides to take a case and issues an opinion with respect to that case, that becomes the law of the land. There is no place left to appeal if it's the United States Supreme Court. The analog in New York State is the New York Court of is the Court of Appeals. Supreme Court in New York State is a trial court. That's where you first. It's where they're. I don't know how else to say it. A trial. If it's a trial by jury, there is a jury there. But the highest court in New York State, which is the highest court, it's perfectly proper to say that. I'm in my 31st year of practicing law, and that's the right way to say it. The highest court in New York State is the Court of Appeals. You object? Okay. All right. All right. So, matter of Frew Run gravel products, Town of Carroll, is a Court of Appeals case, the highest court in New York State. And that case construed language that is virtually identical to 2303.032 that I just mentioned to you. Although in the Frew Run context, it was not a gas drilling statute, it was a mineral mining statute. But it basically had the same language. It said the locality is prohibited, is preempted from passing local laws relating to the extractive industry, the mining industry. The court said that as far as it was concerned, it was crystal clear, reading the language in its natural and most obvious sense, that phrase, local laws relating to the extractive industry, did not include the local land use ordinance. Okay? So, what we have to do when we look at this, again, what we're trying to remember here, the question here is that the locality is prohibited, is preempted from passing local laws relating to the regulation, close quote, of the gas drilling industry. What does that mean? Gurnett Asphalt, also Court of Appeals, highest court in New York State, has said what we look at is we distinguish between ordinances that regulate property uses, land uses, and ordinances that regulate mining activities. The Court of Appeals has said unequivocally and repeatedly, albeit in a slightly different context, that the legal effect of language virtually identical to the gas mining statute, 2303.03 subsection 2, is that while a town may not regulate the operations and processes of the industry, which is the subject of that language, the town may prohibit the industry altogether using land use laws of general applicability. That's the highest court of New York State. Never been challenged. There's no dicta, there's no footnote anywhere in any other court that says maybe this is wrong, the next time we get a chance we're going to change it. It's good black letter law in New York State. Now, the slightly different context where the highest court of the state has spoken is the context of mineral mining as opposed to gas mining. Sorry to have my back to you. Applying all traditional rules regarding statutory interpretation. By all traditional rules, I mean the things they teach us in law school that every single lawyer agrees with, that there's no dispute about. Okay? Applying all traditional rules regarding statutory interpretation, there is no reason why the language in the gas mining statute should be interpreted any differently than the language in the mineral mining statute. The reason we're dealing with this right now is because there's case law in the mineral mining statute context, and there's no case law on this issue in the context of the gas drilling statute. So we believe that towns are not preempted, and that when the Court of Appeals answers this question, it will hold that a town is preempted from regulating the operations and processes of the gas mining industry, but is not preempted from prohibiting the drilling outright throughout the entire town. Is this a mainstream opinion? Turns out it is. Over the last year and a half, this has become mainstream conservative legal opinion, at least among lawyers who have actually looked at it. In New York State, all the big law firms are in Manhattan. 500-person, 700-person, 1,500-person law firms. But the largest firm in upstate New York is Bond, Schoeneck & King. They're based in Syracuse. They are profoundly, tremendously, phenomenally conservative. If there's an issue between labor and management, they always represent management. No exceptions. This, by the way, is the kind of firm that I used to work in, but mine was larger. But this is what they do. If there's an issue between the environment and industry, they are always with industry. Okay, they are the definition of conservative. All right, Bond, Schoeneck & King very publicly has taken the position that they agree there is absolutely no good reason for the Court of Appeals, when they get this, to construe the gas mining statute any differently than the mineral mining statute. Their opinion is online. And by the way, anybody who wants a copy of this PowerPoint, just see me afterwards and give me a card and I'll send it to you. Now, there's another firm based in Albany. You can't see it here, I'm sorry, it's at the bottom. Whiteman, Osterman, and Hanna. They are a really good firm in Albany. They don't have quite the gravitas, in my opinion, as Bond, Schoeneck & King. But they're known to a lot of...
Excuse me, I don't believe Bond, Schoeneck & King handle environmental law like the constitutional law does. I'm sorry. I've been
Mr. Supervisor, could you please...
Yeah, could you hold your comments or questions until the question and answer period, please? Thanks.
Whiteman, Osterman, and Hanna is significant, I think, because for many people, such as the people at the front of this room here, and again, apparently some of you are in that role in other towns, Whiteman, Osterman, and Hanna was the firm that probably 2 years ago was responsible for educating many of the town boards and planning boards in upstate New York about two things. About the fact that gas drilling was coming. Three things, I'm sorry. Gas drilling was coming. 2303-032 preempted certain things, and road use agreements. Basically what Whiteman, Osterman, and Hanna did about 2 years ago, they made appointments with as many town boards as they could possibly find in upstate New York. They crisscrossed upstate New York. They took with them an engineering company called Delta Engineering. As Guy mentioned, engineering is really important in road agreements and road use matters. And they went to every single town board that they could find with whom they could get an audience. And they said, gas drilling's on its way. Here's 230303 subsection 2. There's nothing you can do about it except road use agreements. Thank you very much. And then they got about 7/8 of the way to the back of the door, and they said, oh, by the way, we almost forgot to tell you, we sell road use agreements. Well, road use agreements are really, really important. You heard Guy talk about that. Road use regulations are important. But the reason I have them up here is because even though this is a firm that went across the entire upstate and told every town board who would listen that the town was preempted by 2303-032, except for road use, now they very publicly have taken the position that that's not the case, that a town does have authority to pass the kind of laws that I'm here to talk to you about tonight. All right. This is their PowerPoint. This says what I just told you. Courts will likely construe the preemption in the gas law the same way it construed the preemption in the mining law. Courts will likely uphold municipal home rule powers. Now, Guy and I do a few of these things, and in 4 or 5, I think, that we've done, we've also been with a lawyer from the Association of Towns. The Association of Towns, I think there's 964 towns in the state, 916 or something like that are members of the Association of Towns. They're a very conservative group also. They have not taken a position one way or another on this issue. But their lawyer, one of their lawyers who presents with us, an associate counsel, has said, here's his PowerPoint. He agrees with what I just told you, that the town is not preempted. And the town does have authority to pass laws prohibiting the gas drilling industry, notwithstanding 2303 subsection 2. Okay, so any law that you pass, Guy talked about this in a different context, must have a rational basis. You can't be arbitrary or capricious. The law must be designed to accomplish the general public good for which it is adopted. Because of this, when we do these laws, what we do is we have findings of fact that are 5 pages single-spaced. What we're trying to do here is demonstrate to anybody who looks at this, whether it's a court or somebody who wants to think about whether this would be a good town to sue, that we were not acting arbitrarily or capriciously. So we put good findings in. We talk about how many truck trips per well site, peer-reviewed studies. We note that Bradford County, which usually for some purposes is held up as a poster child for, yeah, bring it on to the drilling, that Bradford County itself saw an increase in demand on health, educational, emergency response, and so on, public safety costs. And we actually put those in the law. All right. So what would a police power-based law prohibiting certain uses, hypothetically speaking, unconventional gas drilling, look like? Here's language from one that we did recently. This is a law that does not rely on zoning, and this is a town, we took this from one that we did for a town that does not have zoning. And you'll notice it picks up a lot of the things that Guy was talking about. Public nuisance, designed to establish and provide for general land use regulation, public safety, prevention of increased traffic congestion, protection, I'm sorry to read, but this is important, protection of rural and agricultural resources, preservation of the character of the town, preservation of air and water quality, prevention of noise, protection against diminished property values, protection of the public from nuisance, and related land use effects and impacts. You do, as a New York State town, have the authority to pass a law for these purposes, and you are not preempted by 2303 subsection 2 from passing that law. This law is aimed at minimizing or precluding the adverse effect on the town that could result from inappropriate use of the property that could otherwise adversely affect the comfort, peace, enjoyment, health, and safety of the surrounding land. Okay? Now, it's really important, whether you're doing one of the laws that Guy talked about or whether you're doing this kind of law, you have to realize who's going to be on the other side. You got to do this right. You do not want to pull one of these laws from the internet. You want to get a lawyer to do it, and somebody who's done a bunch of these. Here's an example of what we do when we're doing one of these laws, and we want ironclad, tight, defined terms. So our defined term for natural gas or petroleum extraction, exploration, or production waste begins as follows. Any of the following in any form, whether or not any of these items have been accepted or exempted from the coverage of any federal or state environmental protection laws, or have been accepted from statutory or regulatory definitions of hazardous materials, industrial waste, toxic substances, and so on. You may say, why do you need that? Well, it turns out that for most people, other than people in the oil and gas industry, there are certain protective laws out there. And they start by articulating a list, A through Z, 26 items. Xylene, benzene, toluene, all sorts of bad things. And they say the following, the foregoing, at the bottom of that, the foregoing 26 items are herein for all purposes of this of this statute, hereinafter referred to as, and then fill it in, hazardous materials, toxic substances, or so on. Then you skip a sentence, and then there are hundreds of pages that say anybody dealing with hazardous materials, toxic substances, or whatever we just talked about is subject to the following requirements. The sentence that I skipped says, notwithstanding any provision of this law to the contrary, in the event that any of the foregoing compounds, materials, and so on, listed in A through Z above, are utilized by people in the oil or gas industry, then those materials are not hazardous materials or toxic substances, and so on. I could not make that up, right? So, you need to know that when you're doing one of these laws. Because if you don't know that and you don't draft around that and you simply pass a law that says thou shalt not use hazardous materials or toxic substances or so on within this town, and then you decide, your code enforcement officer decides to go over and write a ticket because they're using these things, which we all agree are carcinogenic and poisonous, they're going to say, hey, this law doesn't, I didn't do anything. This isn't hazardous material. Not when I use it. So that's why you got to be careful on the way you do these things. Okay, so what does one of these laws look like? It's real simple. Subject to the provisions of Clause B below, it shall be unlawful for any person, which is a defined term, to use, cause, permit to be used any land, body of water, building, or other structure located within the town for, and then what looks very simple, any natural gas and or petroleum exploration activities, natural gas and or petroleum support activities. It's a little misleading to say that simple because these defined terms at the bottom, each one of them are about 3 pages long, single-spaced defined terms. But I just told you why we have to do it that way. The subject to provision, Clause B, which actually Mr. Krogh crafted, suggested / crafted, mostly crafted, is an exception. Because you don't want to, he talked before about unintended consequences when you're drafting a law. You don't want to, say, well, I've really done that. I did that nice and tightly. And then you find out that, people can't have gasoline in their garage for their lawnmowers or something. So we don't need to go into this here, but that's what this section does here. We also have in this what's called a hardship exemption. I won't go into that right now, what that's for, but basically it's a mechanism so that if somebody thinks that the application of this law to them within your town causes them serious problems, they basically get to go to the town board in a procedure that is akin in a town that has zoning, which this town does not, but it's a procedure that's akin to a hardship variance to what would otherwise be a zoning board of appeals. Okay, another way to do this, if you don't want to pass a law right now because you're trying to figure out what's going on, is a moratorium. Moratoria is the plural of moratorium. I actually expected, having seen his presentation several times, that Guy would have talked a little bit about moratoria. He did not, and I don't have much here to say on mine since I thought he would. But it's basically a law that's a stopgap or interim measure that's reasonably designed on a temporary basis to preserve essentially to preserve the status quo while the town considers comprehensive land use changes. All right. Can our town be challenged if we pass a law like this? Yes, there could be a lawsuit. There are several things to remember, because people are going to come in and they're going to say to you things such as I mentioned before, you can't regulate the gas industry. Yes, we know. You can't regulate the gas industry. But an outright prohibition using land use laws is not a regulation of the gas industry. They're also going to come in and say, you can't tell, it's un-American to tell me what to do with my property. Well, it's not, with all due respect, it's not un-American to tell somebody what they can do with their property, or more accurately, to tell them what they can't do with their property. From the very beginning of this country, from the day it was formed, it has always, no exception, not for one day, it's always been the case that ownership of private property did not mean that you had the unfettered use to do whatever you wanted to with that property without regard to the impact it had on your neighbors or the community. Okay? That's the law. It's been the law in this country since we had this country. It's been the law in England since 1066. Okay? So that's a little bit misleading on the part of the folks who come in and tell you it's un-American to tell them what they can't do with their property. As a matter of law, Court of Appeals, every citizen holds his or her property subject to the reasonable exercise of the police power of a municipality. Again, we're talking about police power here, not zoning, police power. Court of Appeals, a person's ability to pursue what is otherwise lawful, hypothetically industrial scale gas drilling, may be curtailed if this infringement and deprivation is reasonably necessary for the common welfare. Court of Appeals case again, it is not an effective argument against these laws, these police power-based laws, that they limit the use and may depreciate, and may thereby depreciate the value of a plaintiff's premises. That frequently is the effect of police power regulation, and the general welfare of the public is superior in importance to the financial profits of the individual. Court of Appeals, highest court in New York State. Property rights are always subject to limitations to prevent injury to the right to the community and neighbors. This next language is the most important language in the slide, this language in red. I'm going to read it out loud, and I'm going to read it slowly. This is the Court of Appeals, the highest court in New York State. A municipality is not obliged to permit the exploitation of any and all natural resources within the town as a permitted use if limiting that use is a reasonable exercise of its police powers, which it is, to prevent damage to the rights of others and to promote the interests of the community as a whole. That you can applaud for. Excuse me. A police power-based ordinance regulating property use, this is the United States Supreme Court here. A police power-based ordinance regulating property use will therefore be upheld unless it is clearly arbitrary and unreasonable, having no substantial relationship to the public health, safety, moral, or general welfare. That's a phenomenally low standard. Okay? To overturn this kind of law, the other side has to show that it had no substantial relationship. That's why we've got those 3 to 5 pages single-spaced of those findings of fact. They can't win that lawsuit. Another thing you're going to hear about, people are going to talk about, is takings. They're going to come in and they say, you can't do this, you're preempted. Then they're going to say, okay, well, even if you're not preempted, you shouldn't do it because you shouldn't tell me what I can't do with my property. Then they're going to say, okay, well, even if you can tell me what I can't do with my property and you're not preempted and you do pass that law, then it will be a taking. We don't think so. We actually are certain it's not. As the United States Supreme Court has noted, the notion that a property owner may establish a taking simply by showing that they have been denied the ability to exploit a property interest that they theretofore believed was available for development is quite simply untenable. That's quoting Penn Central, which is a United States Supreme Court case. All right. When we get this far, sometimes people say, well, maybe that all makes sense. It usually makes sense. But maybe we should wait until this all gets sorted out, because 2 towns have been sued on this issue. The town of Dryden nearby has been sued by a gas company, and the town of Middlefield, which we all know as Cooperstown, has been sued by a landowner. So some people say, well, wouldn't it be prudent to wait for the resolution of the Dryden and the Middlefield suits before we pass any kind of protective law so that we can minimize the risk that our town will similarly be targeted by fracking proponents and might have to spend taxpayer funds on legal fees to defend such suits? Well, assuming that a town has decided that it is in its best interest to pass a moratorium or a land use law to prohibit industrial-scale gas drilling, and that the only question is whether it would be better to pass such a law before as opposed to after the Dryden and Middlefield suits get passed, we believe passing such a law after issuance of drilling permits by the DEC increases a town's potential financial exposure to fracking interests by hundreds of thousands, if not millions of dollars, as we'll talk about. Experienced lawyers agree that final resolution of the Dryden and Middlefield lawsuits will take at least 2 years, start to finish, all the way up to the Court of Appeals, which is the highest court in New York State. And everyone agrees that it's almost inconceivable that the DEC will not have begun to issue drilling permits by then. So when you say maybe we should wait until those suits get to the Court of Appeals, the effect of that is you're saying maybe we should wait until the permits have issued. Waiting to pass a protective law until after the DEC begins issuing drilling permits deprives your municipality of the single protection for local control that the DEC has built into its draft SGICE. And that's the right to say that a proposal to frack in town is, quote, inconsistent with local land use laws. You can't check that box. You can't force the applicant to check that box if you wait for the DEC process to complete. That's really important to keep in mind. More importantly, if you care about money, waiting is not the fiscally responsible thing to do. We believe that waiting to pass a protective law until after permits issue actually affirmatively exposes the town's taxpayers to hundreds of thousands or even millions of dollars of potential liability. Liability that does not exist, or at least is dramatically lessened, if a town passes its protective law before the DEC begins issuing permits. This is why this is the 7th one of these that we are doing this week. This is why we're booked through the second week of January, going all over, because the people have looked at this, asked their own town lawyers. I'm not bringing Guy into this on this, but on the places where we are, they agree with this, and whether they agree with fracking, whether their people are divided, whether the board is divided, they're saying, let's do this now, let's get something in place before the DEC issues permits, and we can do something later different if we decide that that's what we want to do. Because it's too late. It may be too late if you wait. This is so because bringing a successful regulatory taking lawsuit requires, let me back up. Everybody knows what a taking is, or they think they do. Okay. Let me back up even more. A taking, the Constitution says that if there is a taking of private property for a public purpose, then the sovereign, the person who took it, the government, has to pay, quote, just compensation. So the typical taking situation that most of us are familiar with is something called eminent domain. The people decide, the town board, the city council, whomever it is, the state decides that they need 10 feet in front of your house to widen the highway. Permanently, they're going to take it. Or they decide that they need 1 foot, half a foot, on the corner of your house, if you're in a corner lot, just for 2 days for a temporary construction easement. It doesn't matter if they took 200 feet or 1 inch. It doesn't matter if it was a permanent taking where they took it or whether they just took it for 2 weeks for construction. That's a taking. and the sovereign has to pay. It might be a $1 taking if it's just 1 inch and it's 1 day, but it's a taking. The definition of that taking is that there's a physical dispossession of your property by the sovereign. Okay? It's easy stuff. There's nothing to talk about. There's nothing to fight about except what it's worth if there's a taking. A regulatory taking is an entirely different animal. A regulatory taking, let me give you an example. I don't really know where I am, but let's say on the other side of the gym wall here, I own property straight back for 500 feet, unimproved property. And at the end of that 500 feet, there is Cayuga Lake or the ocean or some magnificent body of water. And the people in the front of this room, in their wisdom, decide that they're going to pass a law that says that I can't build anything on that property that I own between the back of that wall and the ocean, because they want all the rest of you to be able to look at the water. And let's assume, just for purposes of this discussion, that that's a public purpose. That is a taking, even though there's no physical dispossession by the sovereign. Okay? It's still my property, but that's a taking. It's a taking because they didn't ask Guy when they did the law, and they didn't leave me any value. If they had consulted Guy and told them what they wanted to do, and let's say what I would like to do is build a 13-story condo on that property, Guy would have said, no, you know what, let's do it differently. Let's let him build 1 story there. Okay, everybody can still see over it, and then that way it won't be a taking. It's not that it's a taking, but it's $1. It ain't a taking at all. That's because generally speaking, I have to say generally speaking because at the question and answer part, I think Mr. Krogh is going to refine my answer for me, having been through this a couple times. But generally speaking, in the context of a regulatory taking, the standard is if there is more, it's kind of a double negative, if there's more than a de minimis amount of value left after this so-called regulatory taking, the law is what is alleged to be a regulatory taking. If there's more than a de minimis amount of value left, it's not a taking at all. That's really important. So basically, what we're talking about, let's say that, let's get off my example. Now let's say that I have stables or kennels. I've got a lot of property and I have kennels. And I want to lease. And you pass a protective law in your town that doesn't let me lease. And my lawyer, who fell asleep in constitutional law, I think, says, you can't do that, that's a taking. Because he stayed awake long enough, he or she stayed awake long enough for the eminent domain part, but not the regulatory takings part. So my lawyer comes in and says, hey, I'm going to sue you for a taking. Well, guess what? We can't stop him from suing, but he's not going to win. He's not going to win because even though, as that kennel owner, that stable owner, whatever I am, I no longer have the right, if I had it before, to say gas drill there. I still have the right, whatever right I had before. I still have the right to have a kennel. I still have the right to have a stable, whatever else I could do with that property. That's more than a de minimis amount of value left, not a taking. There's a whole bunch of other issues why that's not a taking that have to do with the nature of oil and gas itself. Little known fact, fun fact as my daughter would say, in New York State, you do not own the gas that is under your property. I'm not going to go into a lot of detail, but that has all kinds of implications for takings claims too. All right, so let me come back to where I was. Bringing a successful regulatory taking claim requires the claimant to prove that it had a, quote, reasonable investment-backed expectation, close quote. And the calculus involved in proving that claim changes dramatically depending upon whether the law, the alleged regulatory taking, being challenged was enacted before or after the DEC issues permits. Is that clear? That's really important. It's also important to understand what the Dryden and Middlefield lawsuits are and what they're not about. Those lawsuits involve a single issue. In a regular lawsuit that you might know about, there are facts and there's law. Facts are things like, did I look both ways when I stepped off the curb? Was the sun coming up and blinding the driver? Did I have my signal on? Those are facts. And sometimes, often, there's more than one issue of law involved. These suits involve no facts, and both suits involve only one and the same legal issue. And that is whether a town has the legal authority to pass a land use law prohibiting gas drilling. In other words, whether or not 230303 subsection 2 preempts local authority. Mainstream conservative legal opinion, I told you who some of those were, Bond, Shennick and King, Whiteman, Association of Towns Lawyers, and really, except for gas lawyers, lawyers across the state at this point. No exaggeration. It has been literally a paradigm shift on this issue in the last year and a half. Mainstream conservative legal opinion is that New York State's highest court will confirm that municipalities have the authority to pass these laws to ban high-impact land uses such as drilling. Neither of those suits, and these people are going to come in and they're going to tell you, we're going to sue the pants off you, we're going to sue you for bazillions of dollars. Neither of these suits seeks any damages from the town for passing the law. Neither alleges any so-called takings liability. The Dryden suit, the one brought by the fracking company, was brought by a so-called super lawyer. If you go to his website, he's a super lawyer. I made that part up. He's not really posing. But it does say he's a super lawyer. That lawyer's own papers allege that his client fracking company has spent $4.7 million for leases. Yet that super lawyer is not alleging a taking, not for the $5 million or for any other amount. That super lawyer is not seeking even 1 penny of financial damages under any theory or claim. You want to guess why? Super lawyers do not leave $5 million of their clients' money on the table if there's anything they can do about it. Those suits, well, we're talking Dryden now, but they're the same, seeks only to overturn the town's right to pass a land use law that has the effect of prohibiting drilling. So this means, win or lose, a town's downside in these cases, in these two cases, that's all I'm talking about right now, is the cost of defense. In other words, tuition for his kids coming up, okay? Legal fees. Why is that again? They are not seeking any damages, okay? Now, this part I should have taken out since I'm in Enfield and Guy is here, but this is part of what I tell people as I go around. There are very, very, very competent lawyers and very, very, very good law firms, including Manhattan law firms that I alluded to before, that are willing to defend municipalities for either steeply discounted or even no fees in these lawsuits. They do that for two reasons. They do it. The first reason is because some of them are just angry that the way some of these towns are getting pushed around and threatened by the frackers. And then, frankly, they do it for marketing. These are very high-profile cases. By the way, when you do marketing and you do cases like this, you don't say, yeah, I'll do it for free because it's marketing if you think you're going to lose. That would be bad marketing, okay? So they agree with us that the towns are going to win this, and there are a ton of them. I know personally because in both the Middlefield context and the Dryden context, my wife and I were contacted with people who offered their services. Now, there are a lot of reasons why a town might not want to take somebody up. You know Guy, you know how good he is, you don't know somebody else from Adam, so yeah, you'd rather, there are times where free's not good. Sometimes free's a great value, sometimes it's not. So there are a lot of reasons a town might not want to do that, but I just want people to know that that is an option out there. Now, where it's not an option, or you don't want it to be an option, then the numbers I've seen thrown around for this kind of suit are anywhere from $100,000 to $200,000 in legal fees. So let's use $150,000 in my hypothetical. All right? I'll come back to that number in a minute. Supporters of the fracking industry admit that a large part of the reason the lawsuits were filed, the Dryden and Middlefield suits were filed, was to have a so-called chilling effect on the movement to enact municipal level bans. What they don't tell you is that they are at least as concerned about when a law is enacted as they are about whether the town enacts a ban. And that's because of what I just told you before about the difference in damages depending on whether or not you pass this kind of law before or after the DEC starts issuing permits. All right, so we're still on the question of should we wait for Dryden and Middlefield to be resolved? Well, Guy said he's not an engineer. I'm not an engineer. But you should ask your highway superintendent. Is there any question that the cost of rebuilding even one road will be more than the $150,000 the town might spend on lawyers to defend your law? So, waiting to take action has the legal effect of depriving the town of the only locality-level control the DEC has built into the draft SGICE, and, in our view, potentially exposes the taxpayers of the town to financial liability which would not otherwise exist if the protective law was passed before DEC permitting begins. Thank you.
Thank you, David. Okay, if we could take actually only a 3-minute break instead so we can allow more time for questions and answers, because it is very important that we get as many questions as possible, and we do have to be out of here by 9:30. So on that note, 3 minutes.